All right, so let's go into day 2 of Julian Assange's extradition hearing. There's an interesting little thing that Murray relates into this, whereas one of his lawyers has to leave to return to Madrid, and he wants to shake hands with Julian Assange, and there's this little slit in his bulletproof glass cage, about which more later. But Assange went to shake his hand, and the security guards wouldn't let him and prevented a handshake. I want to talk about this cage later, but remember, this is a guy who's accused of putting stuff on a website. So, yeah. But anyway, the proceedings started with Assange's lawyer, Edward Fitzgerald, which, according to Murray, shook us rudely into life. He stated that yesterday, on the first day of trial, Julian had twice been stripped naked and searched, 11 times been handcuffed, and 5 times been locked up in different holding cells. On top of this, all of his court documents had been taken from him by the prison authorities, including privileged communications between his lawyers and himself, and he had been left with no ability to prepare to participate in today's proceedings. Magistrate Barrister looked at Fitzgerald and stated, in a voice laced with disdain, that he had raised such matters before, and she had always replied that she had no jurisdiction over the prison estate. He should take it up with the prison authorities. Yes, if people are abusing you, you should take it up with the abuser. Why are you running to the courts for? Fitzgerald remained on his feet, which drew a very definite scowl from Barrister, and replied that of course they would do that again, but this repeated behavior by the prison authorities threatened the ability of the defense to prepare. He added that regardless of jurisdiction, in his experience, it was common practice for magistrates and judges to pass on comments and requests to the prison service where the conduct of the trial was affected, and that jails normally listen to magistrates sympathetically. Barrister flat out denied any knowledge of such a practice, and stated that Fitzgerald should present her with written arguments setting out the case law on jurisdiction over prison conditions. This was too much even for prosecution counsel James Lewis, who stood up to say the prosecution would also want Assange to have a fair hearing. Oh my God! How bad of a judge are you when the prosecution is even calling you out on the treatment of the defendant? Jeez. And that he could confirm what the defense were suggesting was normal practice. Even then, Barrister still refused to intervene with the prison. She stated that if the prison conditions were so bad as to reach the very high bar of making a fair hearing impossible, the defense should bring a motion to dismiss the charges on those grounds. Otherwise, they should drop it. Both prosecution and defense seemed surprised by Barrister's claim that she had not heard of what they both referred to as common practice. Lewis may have been genuinely concerned at the shocking description of Assange's prison treatment yesterday, or he may have just had warning klaxons going off in his head screaming mistrial, but the net result is Barrister will attempt to do nothing to prevent Julian's physical and mental abuse in jail, nor to try to give him the ability to participate in his defense. The only realistic explanation that occurs to me is that Barrister has been warned off because this continual mistreatment and confiscation of documents is on senior government authority. And again, check the podcast. We've recounted all of the evidence of how Assange has been physically and mentally mistreated in prison and the toll it's taken on him. And it is just unconscionable. And I'm not going to read this part, but he talks about a WikiLeaks editor being kicked out, and there was this whole big to-do made about it. And so then they later tried to say, oh, well, it was because of queue jumping, when it doesn't make any sense because they called him out by name and title and told him he had to leave. And yeah, so this is a show trial. This is a kangaroo court. As we expected, as we predicted. It's an outrage, but it's not a surprise, sadly. So, the Day 2 proceedings. For the defense, Mark Summers said that the USA charges were entirely dependent on 3 factual accusations of Assange behavior. 1. Assange helped Manning to decode a hash key to access classified material. Summers stated this was a provably false allegation from the evidence of the Manning court-martial. And we actually talked about that specifically on the podcast as well. 2. Assange solicited the material from Manning. Summers stated that this was provably wrong from information available to the public. Yep, Manning went to Assange, not the other way around. 3. Assange knowingly put lives at risk. Summers stated that this was provably wrong from both publicly available information and from specific involvement of the U.S. government. And he also said that the U.S. government knew that the allegations being made were false as to fact, and they were demonstrably made in bad faith. This was therefore an abusive process which should lead to dismissal of the extradition request. He described the above 3 counts as rubbish, rubbish, and rubbish. So then they go through the facts of the case, and we covered a lot of this in the podcast. But Summers went through each count, and Murray gives some highlights of it, and I'll read some of those out, like, Summers at great length demonstrated conclusively that Manning had access to each material provided to WikiLeaks without needing any code from Assange, and had that access before ever contacting Assange. Nor had Manning needed a code to conceal her identity as the prosecution alleged. The database for intelligence analysts Manning could access, as could thousands of others, did not require a username or password to access it from a work military computer. Summers quoted testimony of several officers from Manning's court-martial to confirm this. Nor would breaking the system's admin code on the system give Manning access to any additional classified databases. And he quoted evidence directly from the court-martial. But Barrister said, if Chelsea Manning did not know she could not be traced as the user who downloaded the databases, she might have sought Assange's assistance to crack a code to conceal her identity. From ignorance, she did not need to do that, and to assist would still be an offense by Assange. And it's like, really? Yeah. Summers pointed out that Manning knew she did not need a username and password because she actually accessed all the materials without one. Barrister replied that this did not constitute proof she knew she could not be traced. Summers said in logic it made no sense to argue she was seeking a code to conceal her user ID and password when there was no user ID and password. Barrister replied again he could not prove that. At this point, Summers became somewhat testy and short with Barrister and took her through the court-martial evidence again. And it's like, yeah, do we understand how burden of proof works here? No, this is justice turned entirely on its head. After a brief break, Barrister came back with a real zinger. She told Summers that he had presented the findings of the U.S. court-martial of Chelsea Manning as fact, but she did not agree that her court had to treat evidence at a U.S. court-martial, even agreed or uncontested evidence or prosecution evidence, as fact. Yeah, it's just what one of the parties to this exchange said under oath and was verified in court. I mean, if you're not going to accept that, then what can you accept? Summers replied that agreed evidence or prosecution evidence of the U.S. court-martial clearly was agreed by the U.S. government as fact, and what was at issue at the moment was whether the U.S. government was charging contrary to the facts that it knew. Barrister was now making no attempt to conceal a hostility to the defense argument and seemed irritated that they had the temerity to make it. This burst out while discussing the Iraq War rules of engagement. Summers argued that these had not been solicited from Manning, but had rather been provided by Manning in an accompanying file along with the collateral murder video that showed the murder of Reuters journalists and children. Manning's purpose, as she stated at her court-martial, was to show that the collateral murder actions breached the rules of engagement, even though the Department of Defense claimed otherwise. Summers stated that by not including this context, the U.S. extradition request was deliberately misleading as it did not even mention the collateral murder video at all. At this point, Barrister could not conceal her contempt. Try to imagine Lady Bracknell saying a handbag or the Brighton line, or if your education didn't run that way, try to imagine Priti Patel spotting a disabled immigrant. This is a literal quote. Are you suggesting, Mr. Summers, that the authorities, the government, should have to provide context for its charges? An unfazed Summers replied in the affirmative. Yes, of course they do! You have to provide context for it. Oh my God! This is just, And then went on to show where the Supreme Court had said so in other extradition cases. Barrister was showing utter confusion that anybody could claim a significant distinction between the government and God. Yes, Murray is someone else who gets it. This is the cult of the omnipotent state, and Barrister is one of the high priests. It is up to her class and her class only to interpret the Bible, the law, and anyone who dares suggest otherwise is just being outrageous. So remember how a lot of this is based on the fact that Assange put all of these people at risk by publishing their names? Well, Summers described at great length the efforts of WikiLeaks with media partners over more than a year to set up a massive redaction campaign on the cables. And this is not unknown. We've talked about this. This is publicly available information. It actually happened. He explained that the unredacted cables only became available after Luke Harding and David Lee of The Guardian published the password to the cache as the heading to Chapter 11 of their book WikiLeaks, published in February 2011. Nobody had put two and two together on this password until the German publication Der Freitag had done so and announced that it had the unredacted cables in August 2011. Summers then gave the most powerful arguments of the day. The U.S. government had been actively participating in the redaction exercise on the cables. They therefore knew the allegations of reckless publication to be untrue. Julian Assange and Sarah Harrison instantly telephoned the White House, State Department, and U.S. Embassy to warn them named sources may be put at risk. Summers read from the transcripts of telephone conversations as Assange and Harrison attempted to convince U.S. officials of the urgency of enabling source protection procedures and expressed their bafflement as officials stonewalled them. This evidence utterly undermined the U.S. government's case and proved bad faith in omitting extremely relevant fact. It was a very striking moment. And so the prosecutor, James Lewis, said he'd reply later, but he also didn't accept the court-martial evidence as fact, which again is ridiculous, and particularly does not accept any of the self-serving testimony of Chelsea Manning, whom he portrayed as a convicted criminal, falsely claiming noble motives, even though the particular testimony they're talking about was either agreed to or uncontested by the prosecution. The prosecution generally rejected any notion that this court should consider the truth or otherwise of these facts. These could only be decided at trial in the USA. Then, to wrap up proceedings, Barrister dropped a massive bombshell. She stated that although Article 4.1 of the US-UK extradition treaty forbade political extraditions, this was only in the treaty. That exemption does not appear in the UK Extradition Act. On the face of it, therefore, political extradition is not illegal in the UK, as the treaty has no legal force on the court. She invited the defense to address this argument in the morning. They did it on day 3, but again, I've been going on about this for so long that I think we'll do this in a third video. I might do one video for each of the 4 days, so we'll see you then. Until next time, stay strong and be free.